স্বাগতম Lucent আইছলৈকে আমি এইটো ভিডিঅ'ত 16 মে 2025 কাৰেণ্ট এফেয়াৰ্ছ পাৰ্টটো ডিছকাছ কৰিম। আমাৰ প্ৰথমটো টপিক হ'ল ৰেচন কাৰ্ড ইজ মেড মেণ্ডেটৰী ফৰ ফি ৱেভাৰ ইন আছাম। অ'কে, নাও হোৱাট ইজ এ ৰেচন কাৰ্ড? ৰেচন কাৰ্ড হ'ল ইটছ এ অফিচিয়েল ডকুমেণ্ট ইছ্যুড বাই ৰেচপেক্টেড ষ্টেট গভৰ্ণমেণ্টছ। কোনে কৰে? ষ্টেট গভৰ্ণমেণ্টে কৰে। উইথ দ্য হেল্প অফ দিছ কাৰ্ড কোৱালিফাইং হাউচ হোল্ডছ কেন বাই ফুড গ্ৰেইনছ at subsidized rates according to the National Food Security Act 2013. Previously, based on state government identification, qualifying households could buy food grains at subsidized rates via targeted public distribution system. য'ত আগতে এখন ডায়েৰী আছিলে, ৰেচন কাৰ্ডখন লৈ যায়, তাত ৰেকৰ্ডখিনি ৰখা হয়, এটচেট্ৰা। In 2013, National Food Security Act was passed to provide a certain quantity and quality of food to people at affordable prices. Currently, the state governments that have implemented the NFSA has two types of ration cards. So, এতিয়া আমাৰ দুটা টাইপৰ ৰেচন কাৰ্ড আছে। ফাৰ্ষ্টটো হ'ল PHS বা প্ৰায়ৰিটি হাউচহোল্ড ৰেচন কাৰ্ড, নেক্সটটো হ'ল NPHS বা নন প্ৰায়ৰিটি হাউচহোল্ড ৰেচন কাৰ্ড। অ'কে, এতিয়া আমাৰ এই দুটা আছে। বা যদি আমি আগৰ পৰাই চাওঁ, হিষ্টৰিকেল দেয়াৰ ৱেৰ 5 টাইপছ অফ ডিফাৰেণ্ট ৰেচন কাৰ্ড। এটা আছিলে, এটা হ'ল priority household. This card is given to households that meet the eligibility criteria set by government, or each household is entitled to 5 kg of food grains per month per person. Antyodaya Anna Yojana ration card. This card is issued to households that are identified as Antyodaya families by the government, or each household is entitled to 35 kg. Above poverty line APL ration card issued to households living above the poverty line. BPL living below poverty line. Annapurna Yojana ration card was given to older people who are poor and above 65 years. Okay, currently আমাৰ দুটাই ইউজ কৰা হয়। নাও গভৰ্ণমেণ্টে এতিয়া আমাৰ কি কৰিছে, আসাম গভৰ্ণমেণ্টত যে আসাম গভৰ্ণমেণ্টৰ দিয়াৰ ইজ এ স্কিম আণ্ডাৰ হুইচ ষ্টুডেণ্টছ গেটছ ফ্ৰী এডমিশ্যন, অ'কে, in the educational institutions. Now for admissions under the fee waiver scheme for the academic session 2025-26, government and provincial higher secondary institutions, a ration card will be mandatory. Our Department of Higher Education has partially modified it and earlier memorandum regarding that scheme and announced that only ration card will be considered for determining eligibility under fee waiver scheme. Okay, আৰু ইয়াত কোৱা হৈছে যে ইনকাম চাৰ্টিফিকেট অফ দ্য পেৰেণ্টছ উইল ন' লংগাৰ বি কনচিডাৰ্ড ভেলিড ডকুমেণ্ট। অ'কে, চ' এতিয়াৰ পৰা অসমত যিখিনি আমাৰ ফি ৱেভাৰ যিখিনি স্কিম আছে তাৰ কাৰণে ৰেচন কাৰ্ড হেজ বিন মেড মেণ্ডেটৰী। নেক্সট ওৱান ইজ ইম্পৰ্টেণ্ট, দেট ইজ এ ৰাইজিং নৰ্থ ইষ্ট ছামিট অৰ্গেনাইজ বাই ডনাৰ মিনিষ্ট্ৰী। অ'কে, ক'ত? দেলহিত। নাও ফাইনাৰ, তো ফাইনাৰ ইজ ওৱান অফ দ্য লিডিং এণ্ড অল্ডেষ্ট Apex Business Association in Northeast, established in 1992, headquartered in Delhi. Aru the Rising Northeast Summit, tate Finer is one of the knowledge partner. It's a visionary initiative to showcase the fast economic, industrial and trade potential of the Northeastern region. Now, government under Act East policy, government বহুত খিনি আমাৰ চেঞ্জ আনিছে in the Northeastern regions. Okay, আৰু সেইটো কাৰণে গভৰ্ণমেণ্টে নৰ্থ ইষ্টৰ যিখিনি পটেঞ্চিয়েল আছে সেইখিনি এচিভ কৰিবৰ কাৰণে গভৰ্ণমেণ্ট ইজ টেকিং মেনি ষ্টেপছ। তাৰ এটা ওৱান ষ্টেপ ইজ দ্য ৰাইজিং নৰ্থ ইষ্ট ছামিট, যিটো দিল্লীত হ'বলৈ গৈ আছে। অ'কে, আৰু ফাইনাৰ মানে হ'ল ফেডাৰেশ্যন অফ ইণ্ডাষ্ট্ৰি এণ্ড কমাৰ্চ অফ নৰ্থ ইষ্টাৰ্ণ ৰিজন। অ'কে, ফেডাৰেশ্যন অফ ইণ্ডাষ্ট্ৰি এণ্ড কমাৰ্চ অফ নৰ্থ ইষ্টাৰ্ণ ৰিজনছ। আৰু ইয়াতে 11 হাই ইম্পেক্ট থিমেটিক ছেশ্যনছ উইল বি দিয়াৰ, mainly in IT, renewable energy, agriculture, food processing, textile, etc. Okay, so final important, right? North Summit important. Next is very, very important, the climate taxonomy. Now, what is climate taxonomy? It's a classification system which defines which economic activities can be considered environmentally sustainable or aligned with climate goals. তাৰ মানে let's say a forestation হ'ব পাৰে বা certain steps, okay, যেনেকৈ প্লাষ্টিক বেগছ বেন এটচেট্ৰা, or maybe adhering to pollution norms, etc., or maybe using something which gives less pollution. Now climate taxonomy is a system which define the activities that can be considered sustainable or aligned to the climate goal. Okay, its core purpose is to help investors, companies and policymakers identify and channel investments into activities that support transition to low carbon economy. Okay, আৰু it is one of the platform to avoid the greenwashing মানে কি হয় যে certain activities environmentally clean হিচাপে তেওঁলোকে কাম কৰে but those are not clean. Okay, so Indian Finance Ministry recently released a draft on India's climate finance taxonomy last week. Okay, the proposal gives out a hybrid approach which roll out in phase, starting with qualitative criteria based on national priorities like Net Zero 2070 and Development 2047. আৰু as of April 2024, last year, World Bank report reveals that 47 sustainable finance taxonomies have been introduced globally. আৰু পৃথিৱীৰ কি হয় consistency with stated position on climate action, focus on pathways and trajectories in country context, interoperability and consistency with other taxonomies, মানে বেলেগ কাউণ্ট্ৰিৰ লগত যিখিনি তেওঁলোকৰ আছে ফাইনেন্স টেক্সনমি তাৰ লগত ছাপোৰ্ট ট্ৰানজেকশ্যন এক্টিভিটিজ, promoting use of indigenous technologies, be science-based and transparent, proportionality support for MSMEs, or do no significant harm to other objectives of climate finance taxonomy. Okay, so important. Next is CCU carbon capture and utilization. Okay, now Science and Technology Ministry unveiled its first of kind 5 carbon capture and utilization test beds on National Technology Day 11 May 2025. Okay. तो मेन फीचर की है एडमिनिस्ट्रेटेड बाय DST सेंटर फॉर एनर्जी एंड सस्टेनेबल टेक्नोलॉजी PPP मॉडल. सो डिपार्टमेंट ऑफ साइंस एंड टेक्नोलॉजी फंड इंडस्ट्री डेवलपमेंट एकाडेमिक रिसर्च एंड डेवलपमेंट इनोवेशन इम्प्लिमेंटेशन फ्रेमवर्क दैट मीन्स इंडस्ट्री লগত লিংক আছে. গোল কি হয় ডেভেলপ ইন্টিগ্রেটেড কার্বন ডাইঅক্সাইড ক্যাপচার এন্ড ইউটিলাইজেশন, লোয়ার কস্ট অফ গ্রিন সিমেন্ট থ্রু লোকাল টেকনোলজিজ, ইনোভেটিভ প্রসেস, oxygen enhanced calcination converts carbon dioxide to lightweight concrete blocks and olefins, carbon negative mineralization, carbon dioxide is locked into solid minerals, turning emissions into rocks, vacuum swing absorption, separate carbon dioxide from clean gases and reintegration into construction materials. So these are the certain innovative methods via which carbon is captured and utilized. Now there are two topics. One is carbon capture and utilization, one is carbon capture and storage. Now what is the difference? At a whole, carbon capture and utilization, capturing carbon dioxide and converting it into useful products, whereas in the storage, permanently storing the carbon dioxide in geological formations. End goal, reuse capture carbon dioxide. Yes, end goal, sequester carbon dioxide. Output, products like synthetic fuels, urea, soda ash, building materials, yet no usable outputs. Life cycle, carbon dioxide recycled or repurposed, yes, locked away permanently. Economic incentives, no economic incentives, there is cost in fact. Cement, steel, chemicals, plastic and etc., power plants etc. usually reduces carbon dioxide emissions with partial or full offset, offers permanent mitigation. No geological storage needed, requires geological storage. Now carbon capture and utilization is a set of technologies that allow for the capture and use of carbon as a feedstock for making essential products such as fuels, chemicals, then construction material etc. Okay, so important hoy. Next is bear in Kaziranga. So Assam bear spotted descending. So for the I think yet although yet survey hona in Kaziranga etalake bear khetrot. So recently last year also bear was spotted. Now it's a Asiatic black bear. So Asiatic black bear is IUCN vulnerables, size 71, wildlife protection act 1972, schedule 2. Okay, so it is also known as the moon bear. The Asiatic bear has 7 subspecies, out of which we find Himalayan black bear subspecies in India. Okay. Next, orchids in Kaziranga. So we know northeast is orchid zone. Recently, 70 orchid species across 36 genera were documented. Okay. So orchids are non-native perennial plants of family Orchidacinae. It has over 28,000 species and nearly 1,000 genera, categorized into 3 types. At a whole epiphytic, at a whole terrestrial, at a whole myco-heterotropic. Okay, aru India to Western Ghat there is high endemism, but northeast is the highest species of concentration. Next is very important. Okay, now defense ministers recently spoke about the IAEA WATS. Okay, so International Atomic Energy Agency. What's on Pakistan nuclear weapons? So Atomic Energy Agency hoy ki baru? It's an intergovernmental organization that seeks to promote peaceful use of nuclear energy. established in 1957 as the world's Atoms for Peace organization within the UN, governed by its founding treaty, the Statute of IAEA. Okay, it reports to both UN General Assembly or UNSC, headquartered in Vienna, Austria. In 2005, it was awarded the Nobel Peace Prize. 178 members, India is one of the founding members. Okay. Now, এইখিনি ক্ষেত্ৰত আমাৰ কাৰণে কিয় important? Because in the last few years, 2 questions were asked from this topic. Okay. One is IAEA Safeguards. মানে কি হয়? To deter the spread of nuclear weapons by early detection of misuse of nuclear material technology. Okay. So, the essential component of the international security system. 2020 সুধিছিলে, in India, why are some nuclear reactors kept under IAEA safeguards while others are not? Answer was B. Some use imported uranium and others use domestic supplies. সেইকাৰণে যিখিনি imported হয় আমি সেইখিনি আমি safeguard আনিব লগা হয়. Next, what is the additional protocol? তো ইয়াৰ answer A হয়. Civilian nuclear reactors come under IAEA safeguards after ratifying of the additional protocol. So questions আহিছে recently. তো definitely আৰু কিয় important যদি পাকিস্তান অনা হয় under the IAEA safeguards, then definitely তেওঁলোকৰ যিখিনি nuclear proliferation আছে that can be addressed. Okay. Next topic is nuclear waste and its disposal. So again similar ইয়াৰ পৰা derive কৰা হৈছে. So nuclear power 435 nuclear plants worldwide, production of 10,500 tons of spent fuel per year. Okay. 10% of the world's electricity comes from nuclear power. What is nuclear waste? About 3% of the spent nuclear fuel consists of radioactive fission products. In some countries, the spent fuel is reprocessed to separate the waste from uranium and plutonium. Okay. So waste treatment thakibo eta types of nuclear waste: low level waste, intermediate aru high level waste. Aru waste storage and disposal, near surface disposal eta hol deep geological disposal. Okay. Next is, this is very important for both APSC mains, UPSC mains and interview aru logote prelims. Article 143. Now ki hoy? Article 143 is a power of President to consult Supreme Court. If at any point of time it appears to the President that a question of law or fact has arisen or is likely to arise, which is such in nature and of which public importance, it is expedient to obtain the opinion of Supreme Court upon it. He may refer the question to the court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereof. That means it is comes under the advisory jurisdiction of the Supreme Court. Okay. President may, notwithstanding anything in the provision of Article 131, refer a dispute of the kind mentioned in the said provision of Supreme Court for opinion, and Supreme Court shall, after such hearing as it thinks fit, report to the President after. Okay. Now it is the advisory jurisdiction where President sends references to Supreme Court to clarify certain topics. Okay. So recently, Indian President has sent presidential reference to the Supreme Court to clarify if it can set timelines for President and governors to grant assent to bills amid the row over 142, Article 142. যোৱা মাহত there was a judgment where a timeline was drawn. The case was State of Tamil Nadu versus Governor of Tamil Nadu. Okay, where it was Supreme Court said that it gave time limits. The governors under Article 200 on the bills sent to them by the state assemblies. President under Article 201 on the bills which governor has reserved for President's assent. So এই কেইটাৰ ওপৰত প্ৰেচিডেণ্টে এতিয়া ৰেফাৰেঞ্চ এটা সুধিছে. Okay, under Article 143, and the President sent 14 reference points. Okay, আৰু regarding কিহৰ ওপৰত, it is not only the judgment and some other topics also. Okay, যদি আমি চাওঁ, see Article 143, Supreme Court recently কি কৈছিলে, that laid down specific timelines for the governor and president to act on bills sent to them. So ইয়াতে অনা হৈছিলে timeline for the governors and president. Asserted that Supreme Court should have a role when a governor reserves a bill for president citing possible unconstitutionality. So court suggested in such cases president ought to invoke Article 143 to seek court opinion. Okay. Now, nature Supreme Court's opinion. Supreme Court acknowledged that its advisory opinion under 143 is not binding. Very important, it is not binding. However, it holds high persuasive value and should ordinarily be accepted by both legislature and executives. The non-binding nature does not undermine the court's reasoning or principles used to assess constitutionality. Reference precedent 1970 Special Court Bill case to previously ইয়াতে use কৰা হৈছিলে. Now what is the advisory jurisdiction আৰু ইয়াৰ history কি হয়? তো ইয়াৰে history আহে Govt of India Act 1930 হ'ব পৰা. So to seek the opinion of the federal court on questions of law to questions of fact as well. A question under Article 143 may be referred if it has arisen or is likely to arise, and which is of such a nature and such public importance that it is expedient to obtain opinion of the Supreme Court. That means it is of public importance. Article 145 Clause 3 requires any such reference to be heard by 5 judges, after which the Supreme Court returns the reference to President with the majority opinion. Under the Constitution, President acts on the aid and advice of the Cabinet. The advisory jurisdiction allows her the means to seek independent advice to act on certain constitutional matters. Till now, President has invoked Article 143 for 15 times since 1950. So, this is the case state of Tamil Nadu, jo timeline to bandi dia hoisile. Under 143, eta President reference khudise on 14 questions. Now, Supreme Court, yes, they acknowledge that its advisory opinion under 143 is not binding. Okay, aru jodi ami sao jurisdiction history কৰ পৰা আহিছে Govt of India 1935 পৰা. Okay, আৰু as per Article 145 Clause 3 at least 5 জন judge বহিব লাগিব. Okay, on those cases. Now, can Supreme Court decline to answer a presidential reference? Article 143 Clause 1 states that the court may, after such hearing, as it thinks fit, report to the President its opinion thereon. The word may indicates that it is the court's prerogative to answer the reference. Supreme Court so far has returned at least 2 references without answering. So, etyalake Supreme Court, that means Supreme Court answer to nidibo pare. Okay, etyalake 2 reference ase without answer. Eta hol in 1993 President Shankar Dayal Sharma asked the Supreme Court whether a Hindu temple or any Hindu religious structure existed prior to the construction of the Ram Janmabhoomi Babri Masjid in the area of which structure stood. Supreme Court unanimously refused to answer. Aru logote in 1982 reference made by President 𝐤𝐴LE on the constitutionality of proposed law that sought to regulate resettlement of permanent return of individuals. Okay, it is also not answered. That means Article 143 under jodi President reference ahe tenehole Supreme Court answer nokoribo pare. Okay, now can Supreme Court overturn its April 8 judgment? To recent judgment overturn koribo pare neki? In the 1991 Kaveri Water Dispute Tribunal case, Supreme Court said that Article 143 is not the mechanism for the executive to seek review or reversal of established judicial decisions. That means Supreme Court is কৈছিলে যে executives, presidents, prime ministers, etc. they cannot seek review or reversal via Article 143. When this court in its adjudicatory jurisdiction pronounces its authority opinion on a question of law, it cannot be said that there is any doubt about a question of law or the same in the recent as to require a president to know what the true position of the law question. Supreme Court said that it could not countenance a situation where a question in reference may be so construed as to invite our opinion or settle decision on the court. That means government can file review, okay, but president can give reference, but Supreme Court said that it is not mechanism for judicial decision reversals. Okay, now what is the broader context of the recent presidential reference? See, there is a issue going on with judiciary and executive. We have in the Indian democracy there are 3 organs. One is executive, one is legislature, one is judiciary. Okay, or we don't have watertight separation of power. We have checks and balances. Okay, the issue in the R.N. Ravi case essentially arises out of the interplay of power between central and opposition rule states. Governors appointed by centers are seen to be undercutting elected state governments by their refusal to clear bills. Okay, so definitely it's a federal issue. While the Supreme Court addressed the issue in April 8 judgment, it extended its scrutiny to the powers of president as well. That means not only governor, president power report helped scrutiny anisile and set a 3-month timeline to clear bills reserved for her consideration by governor. Governor Ravi, under fire from Supreme Court for original session, had referred 10 bills to the president. The Supreme Court in its ruling allows states the right to seek a writ of mandamus from the Supreme Court against the president. Okay, to read jurisdiction, This is essentially a right to knock on the doors of courts seeking a directive against the president if she does not decide on the bills. Okay. Again, judiciary or executive were at fault. The government used the ruling to argue that judiciary was undermining parliament or the people's mandate. Attorney General of India said the president was not heard before Supreme Court passed directives to her office to follow. Okay. That means there is a broader perspective, not only that the specific judgment regarding the Governor R.N. Ravi. ইয়াতে আমাৰ এক্সিকিউটিভ জুডিচিয়াৰীৰ মাজত যিখিনি আমাৰ ইণ্টাৰপ্লে হৈ আছে, অলছ' দ্য ফেডাৰেলিজিম আণ্ডাৰ ষ্টেট গভৰ্ণমেণ্ট এণ্ড চেণ্ট্ৰেল গভৰ্ণমেণ্টৰ মাজত, চ' ইটছ অল অফ দ্য ইছ্যুজ আৰ কভাৰ্ড. অ'কে, নাও দিজ আৰ দ্য 8 কুৱেশ্যনছ. এটা হ'ল প্ৰেচিডেণ্টছ ৰেফাৰেঞ্চ, এয়া 14টা কুৱেশ্যন দিছে. এটা হ'ল হোৱাট আৰ দ্য কনষ্টিটিউচনেল অপিনিয়নছ বিফৰ এ গভৰ্ণৰ when a bill is presented to him under Article 200 of the Constitution. Next, the governor is bound by aid and advice tendered by council of ministers while exercising all the options available with him when a bill is presented before him under Article 200. Is the exercise of constitutional discretion by governor under Article 200 of is justiciable? So it's a very important question. আমি জানো প্ৰেচিডেণ্ট আৰু গভৰ্ণৰ দুয়োৰে চিটুৱেশ্যনেল ডিছকাশ্যন আছে, বাট গভৰ্ণৰৰ কি আছে? কনষ্টিটিউচনেল ডিছকাশ্যন, এণ্ড দ্য কুৱেশ্যন ইজ ৱেডাৰ ইট ইজ জাষ্টিচিয়েবল. It spoke about and the question is about Article 361, absolute bar to judicial review in relation to action of governor under Article 200. So these are the questions. So definitely after the reference point answers are made by Supreme Court, we will again come in, again bring in and the lecture on these topics. Again, historical uses 15টা পৰা ইউজ কৰা হৈছে. Delhi law case, Berubari Union, case 1 Bharati case, judges appointment, Kaveri dispute, Ayodhya site, etc. Okay, so constitutional basis আমি already এইখিনি part discuss কৰিছোঁ. Next is, does Article 21 include right to detailed access? So recently in the Pragya Prashna emerging judgment, Supreme Court said that detailed inclusion is constitutional imperative under Article 14, Article 15, Article 21 and Article 38, affirming that digital infrastructure must be inclusive, accessible and non-discriminatory. Okay, so right to detailed access refers to guaranteed ability of every citizen, including disabled and marginalized, to access and benefit from digital, public and financial infrastructure. Okay, so key issues: exclusion of KYC system, visual and motor based tasks like blinking, selfie capture, OTP, validation, etc. for disabled person, non-compliance of ICT standards, denial of basic services, discriminatory design, widening digital divide, etc. Okay, so it is included under Article 21, Article 15, Article 14 and Article 38. Now next is very very important, account aggregators. Now কোন হয়? Account aggregators are RBI regulated entities that facilitate the secure and digital sharing of financial data between individuals and third-party institutions. That means these are certain individuals who maintain the relationship with the customers and the banks. Okay, so the Digital Personal Data Protection Act 2023 provides a legal framework for protecting individuals' digital personal data and ensures that it's shared only with consent. Now, the concept of consent manager is a person or entity that is officially registered with Data Protection Board of India. It provides transparent and interoperable platform to enable data principals to give, review and withdraw their consent. Okay, so account aggregator is an interoperable data blind consent manager. It cannot read consumer data, they cannot resell consumer data. Okay, আৰু account aggregator মানে in India, HDFC, ICICI, Axis Banks, Grow, etc. all. Okay, Kotak Mahindra, Indus Ind, these all are account aggregators. Because now key terms in the PDP Act. Okay, Digital Personal Data Protection Act. এটা হ'ল data fiduciary, who decides the purpose of data processing, data processor, who processes data on behalf, data principal, individual whose data is processed, data processing, personal data and sensitive personal data are critical personal data, categories of data which requires most protection. So rights, there are certain citizen rights given under this act. কি হয়? Right to access. Data principals can request access to their personal data held by organizations. Right to correction, right to data portability and right to eraser. Next is again salient features of the act. এটা হ'ল applicability. It applies to the processing of digital personal data in India, whether collected online or offline or later digitized. কি ষ্টেক হোল্ডাৰ আমি অলৰেডি ক'লোঁ ডাটা প্ৰিন্সিপাল, ডাটা ফিল্টাৰি, ডাটা প্ৰচেছৰ এটচেট্ৰা। আৰু ডাটা প্ৰটেকশ্যন ব'ৰ্ড অফ ইণ্ডিয়া এন ইণ্ডিপেণ্ডেণ্ট বডি ৰেছপনচিবল ফৰ ৰিজলভিং ডিছপিউটছ ৰিলেটেড টু প্ৰাইভেচি এণ্ড ডাটা প্ৰটেকশ্যন। অ'কে, চিটিজেনশ্বিপ আমি অলৰেডি ডিছকাছ কৰিছোঁ। অ'কে, চ' দিজ আৰ certain key stakeholders আৰু features which are included under Data Protection Act. আমি আগতেও পঢ়িছোঁ এইখিনি। You can go through the important points. আৰু journey to the bill 2017 Taxonomy judgment, it is important. Then Justice Krishna Committee, then committee releases draft Personal Data Protection Bill 2021 Joint Parliamentary Committee releases its report on the data protection আৰু 2023 Union Cabinet passed the DPDP bill. Okay, so according to the Data Protection Bill, data can be processed or shared by any entity only after consent. So consent is important. Safeguards including penalties introduced to prevent misuse. All data to be categorized into 3 areas: general, sensitive and critical. Government and regulatory role. Government will have power to obtain any user non-personal data. The bill mandates that all financial critical data has to be stored in India. Data localization. Sensitive data has to be stored in India, but can be processed outside with consent. What companies have to do? Social media firms to formulate a voluntary verification process for user. Sharing data without consent is there will be hefty fine. Data breach will or inaction will again bring in lots of fines. Now Sikkim turns 50 today. So 1975 at that time independence. Sikkim was not a state of India. Sikkim was protected area of Indian Union. By Constitutional Amendment Act 1974, 30 Sikkim was made an associate state of India. However, the federal system of India granting of status of associate state did not have any special significance. Or he karne 30 Amendment Act 1970 was brought in. Or Sikkim was given the state status. Okay. Constitution provisions. Article 2. States as Parliament may, by law, admit or establish new states in the Union on such terms and conditions as it may deem fit. Article 3 describes the process of formation of states in the country, which is as follows: separating territory of the state, combining 2 or more states, combining a state with a part of state, etc. Parliament can do this only by law. Andhra Pradesh was created from Madras State by Andhra State Act 1953. Okay. So Sikkim 50 years, India UK FTA. So India ranked as UK's 11th largest trading partner. Now, why it is important? See, this list is important for prelims. So it's a factual. মই line by line পঢ়ি নাযাওঁ. You go through this list. Why ইয়াতে আমাৰ যিখিনি zero duty হ'ব সেইখিনি ইয়াতে দিয়া আছে. So questions may come in prelims. Say which of the following is given zero duty under the new FTA, India UK FTA. Okay. Next is periodic labor force survey. Data আমি already আগতে discuss কৰিছোঁ. So it gives estimates of key employment and unemployment indicators like labor force participation rate. Now what is it? It is defined as the percentage of persons in labor force of the population which is seeking work. Worker population ratio, it is defined as the percentage of employed persons in the population. Unemployment ratio, defined as the percentage of persons unemployed among the persons in the labor force. Current weekly status, the activity status determined on the basis of reference period of last 7 days preceding the data of survey. Key changes: monthly release of labor force indicators like LFPR, WPR, etc. It will be based on current weekly status, very important for prelims. Quarterly estimates extended to both rural and urban area, etc. Important for prelims only. India's multi-layered defense system আমি already আগতে discuss কৰিছোঁ. So there is 2 here. One is Air Force, one is the Army. Air Force integrated air command and control system য'ত real time awareness আৰু command structure execution কৰা হয়, আৰু whereas Army is Akashi's system. Okay. ইয়াৰ বাহিৰে আমাৰ 4 layer defense. Layer 1 is man portable air defense, layer 2 is surface to air missiles, layer 3 is medium range surface to air missiles, আৰু layer 4 is long range surface to air missiles. Okay, আমি already এইখিনি part discuss কৰিছোঁ. So last topic is the India's steps against Naxals, Operation Black Forest and Operation Kagar. So Operation Black Forest is extensive area. It covers extensive area. Okay, and it targeted the key area of 𝐤𝐴𝐻𝐿 Hill. Okay, which is the strategic location of the Naxals. It is the unified headquarters of the major Naxal organization like People's Liberation Guerrilla Army, Battalion 1, etc. Now Operation Kagar launched by Ministry of Home Affairs aim at eradicating Naxals by 2026. Okay, so Operation Black Forest prelims are important, Operation Kagar important, and we hope the topic is important for mains also. This is all about 16th current affairs. We will again meet tomorrow. Thank you.